Okay. Sticky notes. Pen. Let's see. All right. All right, just a minute, everybody. I am getting myself sorted out here. So, hello, everybody. Hello. Welcome, welcome, welcome. Comments should be on for everybody. Hello, Cat Juice. Welcome in, welcome in. Let me see if I can bump this up a little bit. There we go. Hello. Hi, hello, K-Pras. Lee, hello. Yes, Valentine's Day nails, or, you know, for anyone that doesn't celebrate, just fun nails for tonight. Hello, hi, Sunny. Hello, best girl. So, my goodness gracious, everybody, what a day. What a day. We've had a couple of days here that have been kind of difficult. So, yes, Blue Valentine tonight. We've got some hearts here. Right. So that's our whole topic for tonight. We're going to be going through, oh, thank you. We're going to be going through the situation in New York tonight, everybody. Hello, Tracy. Hello. And good evening, July. Hello. This is quite the to-do that has been going on with the Department of Justice and New York. We've got some resignations. We've got all kinds of crazy business going on. So that's what I will be going through tonight. And there's a lot. There's actually a lot to talk about it. Perfect Valentine's Day gift. Oh, that's funny. Well, thanks, April. Yeah. Oh my goodness gracious. Oh my gosh. So yeah, there's a lot going on. There's a lot going on in the news. There's a lot going on in the government situation, in the legal world. Got the popcorn. We love that. Should we leave the country yet? Hold on a bit longer. Just a bit longer. That's a bit longer. I think at the end of the live, we should do a poll, right? Like, are we all staying or are we leaving? Are we getting out of town? Yeah, this is the craziest. I would have to say, this is just absolutely bonkers. So where do you get a blast? Oh, this is this is a dress shirt. It's a men's dress shirt. I'm not sure where I got it from. Come to think of it, but yep, this is just a regular men's shirt. So it's not letting you pin. Okay. Oh, Sarah, no. How did that happen? I don't know what's going on here. So Canadian company might ask for transfer. That's funny. Oh my goodness. Oh, well, thank you. Thank you very much. Yes, I have a bunch. I'm getting out of here. I don't blame you. I don't blame you one bit. It's been, yes, the dismissal did just come through. The motion to dismiss has been filed just about half an hour ago, everyone. Reinstalled TikTok. Oh, well, thank you, Justy. I appreciate it. I'm just getting started, Les. I'm just taking a couple minutes here to let everyone get their notifications. That's a good question. Where did I get this pen? I'm not 100% sure. I can't quite remember. And let me see. There's actually a base to this, and it's like a street light base. I don't know where the base is, but it's supposed to be a street sign. So there's this base that goes at the bottom and it can stand up. It's pretty fun. I really enjoy it. Hello, nauseous ambiance. Oh my goodness. Yes, that's accurate. Accurate right now. I think we all got a little nausea going on. Nope, we're just getting started, everybody. Just getting started. I thought I'd just wait a couple of minutes for everyone to get their notifications. I know there are several other creators going live tonight, which is great. We love that. And I have been mostly on the tube of you. Hello, Carolyn. Welcome, welcome. But tonight I had planned to do this live and go through what's going on with Eric Adams and the DOJ. And I had originally planned to go at 11 today, but my schedule needed to be switched around. So we are here tonight. So that's our, hello, Dano. Hello, welcome, welcome, welcome. Yes, hello. Yes, happy Friday, Katie. I'm so glad it's Friday. Are you even capable of calling BS? I most certainly am. And in fact, I would call this situation a shit sandwich. That would be my official label for this situation. So, quite right. Yes, the motion for dismissal did just get filed. Now, the order for dismissal has not. There are a lot of steps involved, and that's what, the legal system is notoriously slow, and it's because we have all of these different steps that we have to take. Hello, Taylorina. Good to see you. Yeah, it's not good. It's not a good situation. No final stamp on a dismissal. No. The dismissal was just filed like half an hour ago, and we have no ruling from a judge at this point. Let me know though, while I'm on here, if for some reason I would be shocked if the judge actually did rule on this based off of the motion. So, if that does happen, let me know, but I would be shocked, quite shocked. Yes, BS, I agree. It's a horrible day for federal employees. Oh, absolutely. Oh, you're so right. And after going through Project 2025, everybody, the number one, someone had asked me like, oh, what's the worst thing that's going to happen first? And, my answer was federal employees. The federal employees are under attack, and it doesn't matter how long you've been there or how good you are at your job, no matter what your merit status is. Our federal employees are absolutely being... and they're in trouble. I'm not sure about the 4 o'clock hearing. All I do know is that the motion for dismissal has been filed. That's all I know. Well, I haven't said anything yet, Big Happy. I haven't said anything. What's misinformation? You tell me. Was the motion to dismiss not filed? Because I have it right here. That's not that's not misinformation. Yeah, we've got a lot going on. We've got a lot going on. Forced service employee count yeah. I mean, it's a lot. It's a lot. And our federal employees are definitely taking a hit. Anybody in the federal government right now who is not, pledged to the, situation isn't safe. Slow but here, yay! Didn't Scott what's his name resign? Yes. So I have actually 4 memos and letters that I will be reading, everyone. Once again, I'm just waiting for people to get their notifications here. Once those come, we have people getting notified, I will go ahead and start. We've got 3 letters of resignation, and then of course the request from the DOJ to dismiss. I will be reading through those. Ideology doesn't align with the Constitution. Yeah, there's some questions. Now, anytime we have a question about the Constitution, of course, we need our judges to come in and interpret it. That's what our judges do. So, we might have a different opinion of the Constitution than different people, and our judges will finalize the language. But as attorneys, we all take oaths to the Constitution, and we've got a lot of attorneys here who are saying, I can't do what you're asking me to do. It would violate my oath to the Constitution. And so that's a pretty big red flag that we've definitely got some constitutional issues going on. Put this to dismiss and not get barred. Great question. And I tell you what, look who put it in, right? We'll go through it. I'll go through this. But these are the people here that have signed it. And, you know, then this Mr. Bove. And for anyone who was with me during the Trump trials, while I was reading transcripts involving Mr. Bove, he's not really the brightest bulb on the tree, I guess is how I'd put it. He has things that he wants to do, but kind of forgets that there are rules and laws that you have to follow. So you can't just skip around in a courtroom and do whatever you want. So that's kind of his MO, I guess, modus operandi that I noticed during those trials. So, hello, Kea. It does take a lot, though, to disbar an attorney. And in this situation, I don't see any reason for disbarment. We could have ethical violations, but it takes pretty significant ethical violations in order to disbar an attorney. There's usually sanctions that come first, especially if we don't have a record of really bad behavior. So, yeah, I saw that. Judge Chutkin. Oh my goodness, she's making a comeback. She's like, don't call it a comeback. I've been here for years. Yeah, she's got some work ahead of her for sure. Yeah, this is a lot, everybody. This is huge. This is the big one here. So welcome in, everyone, and I'll just wait about 2 more minutes for those notifications to go around, and then we'll go ahead and get started here. But yeah, and thank you. Yeah, go ahead and share the live, everybody, if you are wanting to let other people know here. You know, the talk's kind of been a little bit odd recently, so anything helps. Why is this important? Well, we're going to have to talk about it, right? We're going to have to talk about, we've got a grand jury indictment here, and we've got a memo instructing the prosecutor to dismiss a grand jury. Again, the grand jury was brought in to see if there was probable cause, and they did. And now we've got a request to just dismiss it, but dismissing it without looking at the merits of the case. And that's one of the most unique things here, is that this Mr. Bovey guy decided to write in a letter to write in the situation like, well, we haven't even assessed the case, but we want you to dismiss it. Like, that's not how that works. And you can try to make it work that way, but, you know, you're going to get blasted for it. First time here, well, welcome, Royal, welcome. Yeah, so I will be reading through different parts here. I'll be reading through the letters. Of course, we have to start with the indictment. Also, you know, we gotta hear both sides. You always have to hear both sides. I also have this, and this was actually filed in October, everybody, where Eric Adams had filed a motion for an evidentiary hearing and for sanctions. So they have been, the defendant's been saying, look, there's some trouble. There's some trouble in River City with this indictment. Now, this was not granted. We didn't have a dismissal situation here. But, you know, he's got some things that he's frustrated with, and a few points. We also have the Department of Justice suing New York. So, you know, that's kind of in play as well. And so, you know, there's always 2 sides to the story when we have 2 different parties involved here. Trouble with capital T, which rhymes with P, which stands for pool. Oh, snappy. Yeah, finally. Yes. Hello. Yes, I've got my sticky note here. I'm actually going to be changing the document in just 1 minute, Deborah. This is the indictment here, and I just wanted to have it kind of on the landing page. Are you still planning to shift lives to YouTube? Yes. I will eventually be completely over on the YouTube. There are just a lot of problems here on the talk. I love my time here, and I love hanging out and doing these lives, and I will continue to as long as the app is up and working. But there are some problems here, especially for creators that do this kind of stuff. So it's been a problem. It's been a problem. I've been struggling a bit with the algorithm, I guess, over here, and the community guidelines. Like I was getting community guideline strikes before I'd even published a post. It had already gotten a strike. I'm like, well, what? wait, who's watching me? So I'm happy to be here. I am Hitch. I'm doing okay. Happy to be here, but of course I will be going full time over onto the YouTube. My plan is for strikes constant. Oh, I know, Tiffany. I know. You just do an emoji and get a strike. But my plan is to be over to the tube by April 1st, and kind of have that full move done. But until then, again, I'm happy to come over here. Yeah, comment violations. I'm happy to be here. It's just they don't make it particularly user friendly over here. So welcome in, everybody. All right. So we are, freedom of speech, Mary's complicated. It's complicated because we've got a private business here running the show. If the government were to purchase, which there's been some scuttlebutt about that, if the government were to purchase, I guess, the talk, then we would have a huge First Amendment explosion, and that would be bonkers. But we'll go forward. We'll go forward. So welcome in. Hello, John. Hello. Only come back for a few creators. Yeah, me too. And I come and hang out with everybody. I like to see how everyone's doing. All right, let's dive in, everybody. It's been a crazy day. It's been absolutely a crazy day. Yes, I do have a Substack account. I'm still figuring out how it all works. So, yeah, I know for you. All right, let's walk through. We need a timeline of what's going on here. So we had here's my timeline. It's so well written out. The formatting's amazing here. So November 6th of 2023, everybody, the FBI seized the electronics for Eric Adams. You probably, if you all are familiar at least a little bit with this case, when that happened, that was kind of a whoop-de-doo-dah. And so they seized electronics, and they came back in July then, so July of the next year for grand jury subpoenas. And this is important because Eric Adams is saying, the defendant is saying there were some problems with the grand jury situation. And he's attacking it from the very first step, which of course Mr. Trump did as well. That was his MO as well, where they said, well, some of the stuff that you told grand jury is not appropriate. So we have kind of our first step here of where the defendant is saying that there's improper prosecutorial stuff going on. So there's grand jury subpoenas here, and then the indictment itself came out September 25th. And this is important. The timeline here is really important. We have an indictment, again, by a grand jury, and we have to remember for an indictment, we only have to have probable cause. We do not need to have guilt beyond a reasonable doubt. Probable cause is kind of our mid-level burden of proof. So if we were to put this on a continuum here, sorry, everybody here, I'm not taking any guess at this moment. So if we were on a continuum of beyond here, a reasonable doubt, which is the highest level of burden of proof, reasonable doubt, there we go. And over here, what we have is a reasonable suspicion to believe criminal activity is afoot. So this is our stop and frisk, and I know that's going to be triggering, but we have a very specific protocol for stop and frisk. So that's our stop and frisk situation. Probable cause is going to be probably about right here. So probable cause. And that's, again, we look to the totality of the circumstances to determine if this particular person may have committed this particular crime. And then we go just a little bit further, and this is where our civil court burden of proof is here, which is on a preponderance of the evidence. So that's kind of like a 51% situation. So we don't have exact numbers when we're working with the continuum of burdens of proof, because, we're lawyers, so we just, have words, and that's not particularly helpful. But that's just kind of how we roll here. All right, so, oh no, the trolls are coming in, yikes. So here, again, this is our criminal court, and our probable cause is what we need for a warrant. So if you want to get a warrant, you need probable cause. That's written in the Constitution under the Fourth Amendment. And then also for our indictment. And you can have a grand jury indictment, or you can have a written indictment. And it's going to depend on your state how they go about doing it. So that'll be up to whichever state you're in. Now, an indictment can come on probable cause, but you can see probable cause is not beyond a reasonable doubt. So that is not a conviction by any means, but it is enough to go forward on a criminal case. So that's where we're at with the indictment being filed. There was probable cause to believe that Mr. Adams did do the criminal actions that were being charged. Then he had his arraignment on September 27th. And then in November, the judge in the case set the trial for April 21st. So I think this is why we're seeing a lot of movement right now, is because of the trial schedules getting going here. Notes for notes, exactly. So that's not very far away as far as the court system goes, April 21st. That's like tomorrow, according to, how we work in court. So I think that's why everything's moving real quick at the moment. Now, let's go back a little bit to November 16th, because we've got some critical pieces here that I want to share with you before I dive in to the charges, and then I'll start reading through the letters, everyone. November 16th, it's noted, there was a UFC event where Adams, the defendant, and Trump were both there and kind of were talking to each other, all right? So here's our first real connection there. November 25th, there was a prosecutor named Williams. Mr. Williams resigned from his position. He was the one that originally had pulled the information together in order to go forward with that grand jury indictment, right? So Mr. Williams, his first name is Damien, and I want to bring this to your attention here, did an opinion piece. This is opinion. This is not news. This is his opinion of the situation. January 16th, and he did this and referred to it as an indictment of the sad state of New York government. He was a former U.S. attorney for the Southern District of New York, and he's saying, look, we need some government reforms. There's some problems here. And his opinion on that situation. So you can look up this piece if you're interested in a little bit more information about that original U.S. attorney involved in Mr. Adams's case. All right, everyone. So I think it's always good to gather as much information as you can and then make your decision at the end. So we've got that. And he resigned on the 25th. As we know, there was a new administration that came in, so he resigned. And keep in mind, these are federal prosecutors that we're talking about, not state prosecutors. They're federal prosecutors in the state of New York, but they are not state prosecutors. Next up, December 12th, looks like Mr. Adams met with the border czar. This is a significant moment to note, everyone. So the defendant had a meeting with the person being put in charge of the immigration situation. And this is really a significant moment, I think, here. January 7th, then, there was this discussion of additional criminal conduct to charge him with. And that information has kind of been put to the side a little bit. I wasn't able to get a lot of information on that, so we'll just kind of note that it's not been made available to the public. January 17th, then the defendant flew down, Mr. Adams flew down, I know I need an S there, flew down and met with Trump in Mar-a-Lago, and they spent some time together there. And then January 20th, he did attend in person Mr. Trump's inauguration. So that happened. And then January 21st, so the next day, Adams sat down for a one-on-one interview with Tucker Carlson. January 31st, Adams went into the DOJ, and they had a very long discussion. So he had been in Trump's DOJ at that point. Next, he had made a second trip just about a week later to D.C. to talk again to the Department of Justice. And then February 10th, we get to our first letter. So we have a letter from the Department of Justice requesting that dismissal of the case. So we have the letter, and then we have Adams thanking the DOJ for their hard work on February 11th. Then we have the resignations that fall after that. So that's just a quick overview of the timeline that we're dealing with here, everyone. All right, so the next thing I'm not going to go through the entire indictment, but I think it's important that we just look and see what the counts are. before I start getting into the letters. So let's look and see how he's actually been charged. I think that should help here. So we have count 2. So let's go back to count 1. He's been charged with 5 counts federally, and some people have asked, can he get charged through the state court? Yes, he could. Usually when we have a federal and state situation where both could be charged, the state will typically say to the feds, go ahead, because we're busy people at the state level as prosecutors. So if the feds want to take it, they've got more resources. So, go ahead. At this point, now that we're dealing with this dismissal question, absolutely the state could come in and charge Mr. Adams with multiple different counts as well. So I'm flipping through here so I can get to count 1, everyone. I didn't mark out which page count 1 was on. The indictment is huge, again, and we have to remember that it was a grand jury that found probable cause. It wasn't just the prosecutor in New York, in the federal prosecutor in New York. We have a full grand jury here. And when we have a jury coming in with probable cause, again, you've got to kind of pause for a moment and think, this isn't a particular person. This is a set of citizens, right? A jury of your peers coming in and saying, we think that there is probable cause to go forward on this case. Now, we've got corruption charges, fraud charges in here. All right, here's count 1. Ooh, here we go. Ended up in trouble. Yeah, yeah. He's, hello. Just, here we go. So let me just let you know what I am going to be taking us through right now. We'll kind of flip through it here. But we have Eric Adams' indictment, and I'll just take you through the charges here. Indictment, charges that are set out by the grand jury indictment. So here we go. Sticky alert. Welcome back, Rain from Colorado. Good to see you too. Oh, thank you so much. So count 1 is conspiracy to commit wire fraud, federal program bribery, and to receive campaign contributions by foreign nationals. I think it's Turkey that's involved. We have Mr. Menendez, who was receiving gold bars from Egypt, I believe. And so now we've got Turkey, I think, on the table. So, again, these are grand jury charges. It's not just a prosecutor in here. We actually have a grand jury. Overt acts, meaning that we've got certain significant steps being made towards a criminal act. So they're sending those out. Yep, here we go. We got Turkey. Was Egypt in here too? Yeah, it could be. I won't be reading through the entire indictment's huge, but I just wanted to give you some idea of what our charges are here. Next, we have count 2, which is wire fraud. And let me just go through the first couple of sentences here to give you a little bit of an idea of the charges we're dealing with. From at least in or about 2018 through 2024 in the Southern District of New York and elsewhere, Eric Adams, the defendant, knowingly having devised and intending to devise a scheme and artifice to defraud and for obtaining money and property by means of false and fraudulent pretenses, representations and promises transmitted and caused to be transmitted by means of wire, radio, television communication in interstate and foreign commerce, writing, signs, signals, pictures, and sounds for the purpose of executing such scheme and artifice. To wit, Adams participated in a scheme to fraudulently obtain matching funds, which is also what we had going on with the George, what was his name? The sweater vest guy. Is it George Santos, I think? He had some matching fund stuff going on as well. The Adams campaign by falsely claiming that contributions qualified for matching funds, when in fact those contributions did not. So again, the sweater vest guy had some very similar charges as well. So it could have actually been the same charge that he had federally. So next up, we've got count 3, solicitation of a contribution by a foreign national. Each one of these is available again on Mr. Adams's indictment, which you can pull up online, and they will list the law that's being allegedly violated here. So we've got United States Code Section 3121 and 3101 or 109 D1A and Title 18. So count 3 here is solicitation. Count 4 is solicitation of a contribution for a foreign national, which must mean that there were multiple situations. This one is saying 2021. This one is saying the incident in 2023 here. Count 5 is bribery. I mean, it doesn't get much more corrupt or plain vanilla, honestly, plain vanilla crime than bribery of a political person. That's what we've got charged here in count 5. And a violation of 18 U.S. Code Section 666 A1B and 2. Title 18 is the criminal title where in the code. So if you're looking for a crime, you're still going to be looking into Title 18. The sweater vest. I just sometimes I can't remember his name. Here we go, and they're alleging there were bribes involved, and we even have some photographs here in the indictment, which is always fun for those of us reviewing these documents. Like here, we have a cosmopolitan suite bedroom. So one of the things that has happened in the past is that you get all of these perks, right? So you get a really nice hotel room or a really expensive dinner, or, for Thomas, like a cruise on a private yacht or a cabin in the woods or a house for his mother, whatever. These are kind of the perks, and those could be seen as bribes because of the sheer amount that's involved and because they're looking for some kind of benefit in exchange. So again, this is the indictment. Grand jury was pulled in for that, and they had a finding of a probable cause to believe Mr. Adams had committed these offenses. So that's our first piece here, everyone. Bigger than your apartment. Mine too. Mine too. So the next thing in order, just to make sure we kind of stay on target here, is that we do have Mr. Adams, the defendant, came in and had filed a memorandum of law, and this was filed in October. So, right before those November situations occurred. So if we look back here at our timeline, November, we've got when the trial was set. We also have the UFC event, and then the prosecutor resigned. All of that happened in November. But before that happened, Mr. Adams had filed a motion for an evidentiary hearing and sanctions. And if we look, it'll see the problems. This is what he's saying happened. The government leaked confidential information. The leaks violated the grand jury secrecy rules. This is where we're saying that there was a problem with the grand jury. And if there's a problem with the grand jury, that could mean a huge problem for the indictment, depending on what's going on. And then Mayor Adams does not need to show prejudice now. So these are the three pieces that they're arguing in here, again, stating that there were problems with that grand jury indictment. And he filed this and, kind of let the chips fall where they would fall. And ultimately the prosecutor resigned, and it was moved to a different prosecutor after that. All right, so if you're looking, this is the case number here, and it is document 40. All right, so that's kind of important. But let's get into our letters now. We've got, oh my gosh, everybody, this is just a mess. So here's our first one, and I will be reading through all of these letters. Let me go ahead and get a sticky note ready here. So this is the first piece that got everything kicked off. And this is a letter requesting the dismissal here. So let me label this, and then I will start reading it. So letter requesting Adams dismissal here. And this was sent out February 10th. All right, there we are. Yes, oh, lots, lots of that. Lots of sticky notes tonight, everybody. Here we go. So we've got a memorandum for acting United States Attorney United States Attorney's Office for the Southern District of New York, February 10th, 2025 here. This is from the Acting Deputy Attorney General, which is signed right here. Now, for anyone who's not really sure how the Department of Justice goes, we have the Attorney General here, Deputy Attorney General here. Now, the Attorney General is chosen by the President and confirmed by the Senate and can be impeached. That's the removal process for the Attorney General here. And then we've got Solicitor General, Associate Attorney General here, and then Legislative Affairs. They're supposed to be a nonpartisan branch that just kind of gives legal information for people who are wondering, like, is this okay? Is this not okay? And then Office of Legal Counsel over here. Then we've got the FBI, Criminal Division, National Security Division, and the Office of Professional Responsibility. So this is the ethics branch, and I'm not sure who's working there right now, but that's how that is. And over here, when we get to that Associate Attorney General, under them, we've got justice programs here, community-oriented policing services, also known as COPS. So this is kind of, for those of you that were with me during the Georgia RICO case, when we had Jim Jordan sending a letter to DA Willis saying, we're going to pull your federal funding if you don't dismiss the case. And she said, our federal funding is for kids to learn about the law, and so that's kind of crappy. This is the area where those kinds of funds are pushed through and these programs are done. And then we have our Civil Rights Division. I don't know if anyone's left there yet or not. Antitrust, Tax Division, Civil Division here, meaning civil rights is the Constitution. A civil division is something where it's involving money. It's not a criminal situation. Environment and Natural Resources Division. Again, I don't know anyone's there right now. Community Relations Services. So that gives you an overall idea of the structure of the Department of Justice. So budgeting concerns. Well, it seems like it. It seems like it. So here we go. We've got the Acting Deputy Attorney General here and signature. And subject is dismissal without prejudice, a prosecution of Mayor Eric Adams. Now, without prejudice means it could be brought later on down the road. If it is with prejudice, it means it can't be brought. So I think probably a great example would be Alec Baldwin, right? They were trying to do homicide criminal cases against him, and the prosecution screwed it up so badly, so many times, that the judge dismissed it with prejudice and said, don't bring this crap back into my courtroom, versus without, which is what this is, saying, you know, you could bring it back again. Here we go. You are directed as authorized by the Attorney General to dismiss the pending charges in U.S. versus Adams in the Southern District of New York as soon as practicable. So there's a few things to kind of highlight. Helpful. Can you make a regular video on it? Oh, sure. I could do that. Absolutely. Yeah, it's hard. I'm not really sure what people know and what they don't know about the different systems here. So absolutely. As soon as practicable. Now, there are a few pieces in here that I'm just going to underline that, as a lawyer, I look at and I ask a question. So we'll get to those questions later. But as soon as practicable, subject to the following conditions. Number one, the defendant must agree in writing to dismissal without prejudice. Now, that's the first piece. So Mr. Adams would have to say, okay, I agree. Number two, defendant must agree in writing that he is not a prevailing party under the Hyde Amendment. So again, this is another piece. And if I should have probably just pulled up the Hyde Amendments. So let me just give you, here we go. Let me just give you a quick explanation. Right. So it's looking like, yeah, that's really weird. I'm not sure how that's applicable. Hyde Amendment. Adams doesn't do what they say they will charge him. Right. Yeah. Yeah. So Agree in writing he's not a prevailing party under the Hyde Amendment, so set out in 1997. I just don't want to take the time, everyone, to piece together the Hyde Amendment. Forgive me. We'll have to keep moving here. We've just got a lot of documents to go through. And 3, the matter shall be reviewed by the confirmed U.S. Attorney in the Southern District of New York following the November 2025 mayoral election based on consideration of all relevant factors, including those set below. So this is important. All relevant factors, that's important. That's a good piece. Yeah, I'm making sure. Can everybody see the chat okay? I just want to make sure I'm lined up all right for that. Okay, thanks, Carol. Yeah, we've got a lot. We've got a lot to get through here. And of course, if it's something the defendant's going to agree to, of course, Mr. Adams has already taken a look at it. All right, thanks, Tiffany. So including set forth below. So relevant factors, that's important. If we've got proper relevant grounds for dismissal, there you go. There shall be no further targeting of Mayor Adams or additional investigative steps prior to that review. And you are further directed to take all steps within your power to cause Mayor Adams' security clearances to be restored. This sentence is suspicious. All right, this is suspicious. There should be no further targeting of Mayor Adams implies that they've been targeting him rather than going through a fair and equal justice system. Just here, they're saying you intentionally were going after him or additional investigative steps prior to that review. So they're saying you may not investigate any kinds of crimes or any problems involving Adams, right? So don't even look and see. So if he had committed some crime, like if he, robbed a 7-Eleven, they're like, nope, no more investigation. And you're further directed to take all steps within your power to cause Adams' security clearances to be restored. Now, you have to wonder, we have this huge corruption situation where he's got a grand jury indictment against him, so his security clearances are pulled. Why does he need his security clearances back immediately? That's a huge question. What is it that he can use his security clearances for that the DOJ wants them to be immediately restored? Like if we're dismissing something and it's going to take some time to get everybody put back to where they were before the indictment, it's going to take some time. But they're saying we don't want to take any time for security clearances. We want those immediately. So I think that is a really good question to ask and what makes it suspicious. So this very first paragraph, in my mind, seems to be written by somebody who's not really acknowledging or understanding the backlash that they're about to get. Right. Suspicious. It's suspicious. Here's the next piece. The Justice Department has reached this conclusion without assessing the strength of the evidence or the legal theories on which the case is based, which are issues on which we defer to the U.S. Attorney's Office at this time. So again, literally saying we haven't even looked at the case. We don't even know what's going on, but we're asking for a dismissal. The reason why this is such a huge red flag, of course, is because you're not supposed to make decisions without enough information to go forward. You have to have a good faith reason for a dismissal. Federal courts award attorney's fees and court costs too. Okay. I'm insulted that they think that we're stupid. Oh my goodness, they really do. So if we take a look again, this is the sentence here, everybody. In fact, this whole thing is like incredible evidence for when this hits court, because he's saying right here, we've reached this conclusion, and the inference then is we don't even have to support our decision. We don't have to look at the facts and the law and see if it's enough to go forward on or dismiss. We don't have to do that. All the Justice Department has to do is look at a name and decide whether or not they're going to keep the case or dismiss it. And that is really, that's a bad situation right there. because now instead of going through this process where they're supposed to be essentially nonpartisan, although of course they are a bit partisan, but as attorneys, we're supposed to uphold the Constitution, right? So that kind of puts us into a little different area. But when you have an attorney here saying, I don't even care what it says, I don't even care what it means, I don't want him charged anymore, and I want his security clearances put back, is incredibly suspicious. So I think, in my opinion, this is going to be the sentence that the judge going through the dismissal motion is going to say, what the H is this? You know, because you need to have some kind of justification. It could be, we just don't think there's probable cause, or we don't have time to go forward, or we want to investigate further, or this is a low priority. There's a ton of different things, but we're at a point where this person thinks that he is so important and special that he doesn't even need to explain why. It's just when he tells you to do something, you do it. And that level of authoritarianism is like not rewarded in our legal system. So this is very suspicious. He's going to resign and be given a White House position. Perhaps. I mean, resignations need to start falling right pretty soon, because this is we're in the red zone here. All right, so this sentence could be put into an ethics complaint against him, quite frankly. Moreover, as I said during our recent meetings, that's that ego again. What a jerk this guy is. This directive in no way calls into question the integrity and efforts of the line prosecutors responsible for the case. Like, he's trying to soften this blow. He's like, I'm not saying it's your fault or your efforts in leading those prosecutors in connection with a matter you inherited. So again, he's saying, because, the woman in charge here, and we'll go through her letter next, Miss Sesson, she's appointed by Trump, right? I mean, she's a pretty conservative lady. And so they're in here saying, well, it's not your fault. You were just kind of given this. Like, all right. So again, we've got an ego situation. However, the Justice Department has determined that dismissal subject to the above described conditions is necessary for two independent reasons. So subject to the above conditions. So we've got three conditions here. One, there's an agreement. One, we're not violating Hyde. And three, it's to be reviewed by the confirmed U.S. Attorney in the Southern District, right? So she has to look at it. That's what this piece is saying here. Sounds condescending. Yes. Can the judge reject it? Yes, it's possible. It's possible for a judge to deny the motion to dismiss, but that will trigger some very interesting roads. We will talk about that once I pull that motion up. I have been able to print that out, even though it was just like an hour ago, and I will be going through that. So first, the timing of the charges and more recent public actions by the former U.S. attorney responsible for initiating the case have threatened the integrity of the proceedings, including by increasing prejudicial pretrial publicity that risks impacting potential witnesses and the jury pool. So I'm not surprised to see this language in here, because this language was used against him when he was representing Mr. Trump. And just saying, when he was on the other side, this is what, Jack Smith was saying, dude, you're kind of screwing up our jury pool here. But just because you think there might be something wrong with your venere, which we all learned about in the DC Trump case, doesn't mean that that's appropriate grounds for dismissal. You can move the case if you think you've got a situation where you can't have a proper jury in there. There's all kinds of reasons that if you think something hinky's going on, you can take the case down another road. It cannot be ignored that Mayor Adams criticized the prior administration's immigration policies before the charges were filed. Now we're in politics. We're outside of the legal system. We're into politics. Politics should never be one of the rationales for dismissing or bringing a criminal case. And this is something that Mr. Trump and his team never really understood, was that, you can't justify what you're doing by using politics as your justification. right? So you can't, well, the Biden administration told me to do it. Like, that's not how that goes. No. So once we start getting into the political land, then the attorney is outside of the realm of what they're supposed to do as a prosecutor. It's not supposed to be that's not supposed to be how it works. So you have to ask these really big questions, all right? Once you're pulling politics in as your justification. The law is the law, and politics is outside of that. So, again, criticizing the prior administration immigration policies before the charges were filed, and the former U.S. Attorney's public actions created appearances of impropriety that implicate the concerns raised in the Attorney General's February 5th memorandum regarding restoring the integrity and credibility of the Department of Justice, as well as this executive order entitled Ending the Weaponization of the Department of Justice. Now, I've read through that executive order, and that's fine. You can put whatever you want in an executive order. That's no big deal. But when you start making legal decisions based off of hearsay, that's going to get you into trouble. So again, some people might say, well, politics were involved, or what if he really was targeted because of immigration policies? Well, how would you know that? How would you know that? Because you have not assessed the strength of the evidence or the legal theories on which the case was based. So you haven't even assessed that. So how would you even know that this criticism of immigration policies was part of it, right? So that's where the problem is. If you read through this case, through this indictment, and you looked in there and you saw how things were connecting in there in order to have some kind of evidence that this was an issue or that this was some kind of a political retribution, then yeah, that's a problem. We can't be having that. But you didn't even look at it. Dude, you didn't even look at it, and you told us you didn't look at it. So how do you even know? This is all hearsay. This is all unsubstantiated situations. Now, this can be your theory. This can be your theory of why he was targeted, in your opinion, that you think he was targeted, but you have no evidence to back it up. And again, I think if this sentence hadn't been included, there may have been some inferences like, okay, well, maybe he looked at the stuff and felt like, wow, this guy's being targeted. But you just told us you didn't look at it. So we know now that any kind of information that you have is basically just unsubstantiated hearsay and rumors, which does not have a level of trustworthiness appropriate for the legal system. Want to drop Adams and not his staff. Yeah. I mean, it's a good point. It's an excellent point. VC. All right. So, and again, I've read that executive order, and the executive order, whoop-de-doo-dah, that's fine. But you can't put executive orders like that into a criminal court and say, well, the executive order told me to do that. Well, if the executive order is bad law, or bad is not law, but if it's a bad charge to you, if it's a bad order, then you're going to be in trouble because you have no immunity. These actions and the underlying case have also improperly interfered with Mayor Adams's campaign in the 2025 mayoral election. And to this, I would say, well, why don't you take a look at Judge Chutkin's orders, almost all of her orders regarding Mr. Trump and his campaign in D.C., because that's the precedent that's been set through the courts, where in the D.C. circuit, she has said it doesn't matter if you're campaigning. When it comes to a criminal case, we have to do what we have to do. We follow the law. We follow the process. And, I get it. I see that you're campaigning, but that's kind of a you problem, not a me problem. So this, again, is another argument that he's pulling from the DC case. Somebody said, I know, that's what I'm saying, Robert. That's what I'm saying here. So, yeah, yikes. That's another piece, again, unsubstantiated hearsay. So give me some evidence, give me some evidence. Second, so that's their first justification for the dismissal. unsubstantiated rumors and hearsay. Give me some evidence, and I'll be like, hey, let's do that. Next, second, the pending prosecution has unduly restricted Mayor Adams's ability to devote full attention and resources to the illegal immigration and violent crimes that escalated under the policies of the prior administration. Now we have our second political piece. So he's saying we need to dismiss it because Mr. Adams has been inconvenienced. Like, that's not a justification for dismissing a criminal case involving bribery and corruption. Like, what? That doesn't make any sense. That makes no sense. Like, what? And he wrote it down. And he wrote it down on paper. This is just like, blah. It's so much. It's so much wrong. We are particularly concerned with the impact of the prosecution of Mayor Adams's ability to support critical ongoing federal efforts to protect the American people from the disastrous effects of unlawful mass migration and resettlement as described in executive order here. So again, this is a political reason. So we don't have a situation where, they said his rights have been violated, we have unlawful searches, we have questionable evidence, or we have information given to the jury that is too prejudicial. We don't have any of that. We don't have any evidentiary rules. You could pull in Rule 401, 402, 403. You could pull in some we could pull in some character evidence rules. You could pull in some, improper, or I would say probably the prosecution was incorrect. Any of those, you could pull those in, but he's not doing that. He's just saying, there's this mass migration and resettlement issue going on. Like, that doesn't relate at all. So with the prosecution, you could say it's an abusive prosecution. That's what I was looking for. I was looking for him to say we have an abusive prosecution here, which is a legitimate legal reason why you might want to dismiss a case, even if it's not proven. If you've got probable cause in a case and you think that there was an abuse of discretion or abuse of prosecutorial conduct, bring it in. Those are legal arguments. This is not a legal argument. This is a political argument. And, we don't use those in court. And so this guy, this just blows my mind that someone was like, I'm special. I can put whatever I want into this memo and everybody has to, kneel down and agree. Like, that's not true. That's not how this works. All right, accomplishing the immigration objectives established by President Trump and the Attorney General is every bit as important, if not more so, as the objectives that the prior administration pursued by releasing violent criminals such as Victor Bout, the merchant of unalive. So this is irrelevant. I would object to this. If he was arguing this in court, I would say, objection, Your Honor. That's completely and totally irrelevant under Rules of Evidence 401. It's completely inappropriate here. And quite frankly, because this attorney is bringing it up, he should be sanctioned. Now I need to go back and double check because his attorneys were actually sanctioned. I think he did get sanctioned in Trump's case in New York. I'll have to double check because I can't remember exactly who got fined, but I think he was fined actually in New York for improper conduct as an attorney. So yeah, this I think is Bove. I think this is that Bovey guy here, but whatever. I mean, the AG's office can't put something this important forward and not have pre-approved it. So this is on Bondi. She's the one holding the reins. This is her responsibility. And then next, accordingly, based on these additional concerns that are distinct from the weaponization problems, dismissal without prejudice is also necessary at this time. Again, we have no legal justification for why the case should be dismissed. We have political justifications that are unsubstantiated rumors with no evidence, but we have no legal reason. That's the funny thing about the legal system, is that we like to have legal reasons to do legal things. Because if you don't have a legal reason, then, you know, you can't do the thing. So this memo is just absolutely the lightning bolt here to end this travesty, miscarriage of justice. He could have said that. Oh, it's a miscarriage of justice. Oh, this is, you know, abuse of discretion. This is all of these things, like a violation of his Fourth Amendment search and seizure rights. There's like 100 different things he could have said, but instead pulled in politics as justification for his legal dismissal situation. And that just shows his lack of really acknowledging that you can't just run your show however you want to run it, that we actually have rules. So there's that. But we do have 2 footnotes. Maybe that ought to clarify it for us here. Maybe that ought to clarify it. Number 1, your office correctly noted in a February 3rd, 2025 memorandum, quote, as Mr. Bovee clearly stated to defense counsel, again, this situation is rude. During our meeting on January 31st, the government is not offering to exchange dismissal of a criminal case for Adams's assistance on immigration enforcement. This is what they're using as the, what did Mr. Trump call that one clause in his, Engeron case where he's got to pay like $500 million? What did he call it? The no enforcement, or the dummy clause? I can't remember. Do you guys remember that? The clown clause. No, there was a clause in the paperwork, and it said the Santa Claus. Oh my gosh, what was it? Does anyone remember? Yeah, Carol, I know, right? Alternative facts. Oh, that's so funny. No, it was like the dummy clause, or the, what was it? Oh my gosh, hold on, everybody. I gotta find it. I blocked it from my memory. Dumb clause. Oh my gosh. The relentlessly stupid clause? No, that's not right. I can't. Oh my gosh, what was it? In New York. I can't move on, everyone. I've got to know the name. Disclaimer, we're getting there, but he called it something. Part of, right, nope. Hold on. Worthless, oh my gosh, who said that? Who said worthless? All right, Miss Julie, you're the winner tonight. Winner. Oh my goodness. Oh my gosh, thank you so much. The worthless clause, everybody, where it says, please don't believe anything that I just wrote in this document. And Engeron's like, it is a disclaimer clause. Yes, it is. And Engeron was like, no, that's not how these clauses work, sir. So this is basically what he's trying to say is the worthless clause. So just because we want him to help us with immigration doesn't mean that we're actually asking him to, which is just like, you have the do your own research clause. Oh my goodness, yes. Do your own research, yes. So it all comes back to the Trump cases, everybody. I tell you, every legal theory can be. You can walk through those Trump cases. Right, he should have made it. That's better. All right. So this is their worthless clause, again, saying this is not a quid pro quo because we're saying it's not a quid pro quo, so it must not be. So next up we have, according to an October 2024 Wall Street Journal article, which of course is incredibly valuable and, helpful for a court of law, Bout has already started to participate in arms deals again. And again, I asked what the relevance is here, including negotiations with representatives, this guy, also known as this guy. This is not relevant. How is this relevant to dismissing Adams's claim. It doesn't have any relevance, but it shows the person who wrote this memo is not concerned about the issue at hand. He's not concerned about Adams and the 5 counts. He's concerned about this dude and how bad this dude is, which is, again, one of the weakest links for Mr. Trump was he's saying, well, what about Hillary's emails, right? What about the emails? What about the laptop? Like, dude, we don't do that in court, man. You gotta, these are each separate individual issues. You can't just smash them all together. So this would be an F. That would be an, oh my gosh. I think it's Bove. I mean, because I think we've got, I don't know, we've got a signature here. So I don't know, GB3, I don't know. But whoever this person is, GB, E, I don't know. But that person is. And can the governor or state stop his non-state or challenger? Okay, can the governor or the state or the judge stop his... I'm not sure what you mean, David. I'm not sure what you mean on that. Can the judge refuse the motion to dismiss? Yes. Can the governor pull the mayor? Yes, it's possible, but there's processes that we have to use. All right, so next one up. All right, this is bad. Stopped this, what? I'm sorry, stop this nonsense, what they're doing. I still don't understand. I'm sorry, David, I just do not understand. His first name's Emil. Yeah, so Emil Bovee. I don't know, everybody. We'll put that one to the side. Here we go. Next up, then, we have the resignation. So this is the big one. Oh, yeah. I mean, we're just getting started here, Robert. We're just getting started. We're getting warmed up. So that was the pregame show. Here we go. Next up, let's get our sticky note here. No, I don't have 7 letters, although that would have been very interesting. But no, I just have the, so this is the AG, or the attorney, right, who resigned. So this is Sassoon's resignation letter here, all right? So we'll go through that. Yep, sticky note right here. Thank you for the reminder. So we've got Sassoon here. Sassoon resignation letter. Resignation letter. Does anyone even print anymore? Like, this is so weird. I don't have spell check on my little sticky note here. So we'll do, and then I'll just put the Adams case down here so everyone knows what I'm talking about. This is crazy. Oh, I know. Can the governor say no to the dismissal? No, the governor's not involved in that. Thank you, Navy vet. No. No, this is all through the courts. You have to, once you bring a case, and particularly once a jury has been brought in, a grand jury, and has listened to the evidence and gone forward. No, this is all in the legal system. The governor doesn't have any say over it, or anyone else. And that's one of the problems here, is that the AG is like, well, we just want to dismiss it, even though we don't know what the case is about. That's kind of what the crux is. She could fire Adams. It's possible. Yes, it is possible that the governor could fire him. He, of course, would go through a due process, though. So she would set out and say, these are the things that I think you did that are wrong. And he would come back and explain they weren't wrong, essentially like a little mini trial, and then go forward from there. So there is a huge due process that has to happen when you're in New York if you're going to pull a mayor. So next up, we have the resignation letter, and this was put in February 12th. So this last monstrosity was sent to her, and then here's what she wrote. So, dear Attorney General Bondi, who at the end of the day is the one responsible for this, on February 10th of 2025, I received a memorandum from Acting Deputy Attorney General Emil Bove. So there we go. Confirmation. This is from Bove, everybody. All right. Again, I think he was actually fined in New York. I think he was actually sanctioned. There were several times when he got called out by the judge who was saying, wow, that's not, watch your ethics, dude. directing me to dismiss the indictment against Mayor Eric Adams without prejudice, subject to certain conditions, which would require leave of court. I do not repeat here the evidence against Adams that proves beyond a reasonable doubt that he committed federal crimes. She's using this high level, right? So beyond a reasonable doubt, which we know is the highest level. So she's saying we even have more than probable cause. We have the highest level of proof that we can show. So that probable cause is nothing compared to what we actually have. So this again is another big red flag that he committed federal crimes. Mr. Bove rightly has never called into question that the case team conducted this investigation with integrity and that the charges against Adams are serious and supported by fact and law. Again, fact and law is another key phrase that could be used in court. Mr. Bove's memo, however, which directs me to dismiss an indictment returned by a duly constituted grand jury for reasons having nothing to do with the strength of the case, raises serious concerns that render the contemplated dismissal inconsistent with my ability and duty to prosecute federal crimes without fear or favor and to advance good faith arguments before the courts. So this is the key right here. She's saying this would violate the oath I took. And that's what this is looking like. A lot of people are saying, well, who's going to enforce, who's going to enforce, who's going to enforce? And the court orders. And one of the big things here is that we have attorneys saying, look, we've got ethics. We can't actually do what you're ordering us to do because that would violate the Constitution and that would violate our oath that we took. So, and I want, she is amazing. Yeah. And one thing to note too, everybody, that I think is really important as we go through this is at the end of this, once we get to the end, you have to think if somebody does file that motion to dismiss, then they could very easily be seen as an attorney who's willing to toss aside their oath. They don't have any ethics. They don't really care about their ethics. They're willing to just do whatever they are told to do. And that's where the problem is. The problem's with the person, not the situation. Yes, Miss Julie, yes, I have it right here. And we'll go through that here in just a little bit. Next up, so when I took my oath of office 3 weeks ago, I vowed to well and faithfully discharge the duties of the office on which I was about to enter. In carrying out that responsibility, I am guided by, among other things, the principles of federal prosecution set forth in the Justice Manual and your recent memoranda instructing attorneys for the Department of Justice to make only good faith arguments and not to use the criminal enforcement authority of the United States to achieve political objectives or other improper aims. So she's quoting back to the AG, her own language. We always love that. I'm also guided by the values that have defined my over 10 years of public service. You and I have yet to meet, let alone discuss this case. But as you may know, I clerked for the Honorable J. Harvey Wilkinson III on the U.S. Court of Appeals for the Fourth Circuit and for Justice Antonin Scalia of the United States Supreme Court. Both men instilled in me a sense of duty to contribute to the public good and uphold the rule of law in a commitment to reasoned and thorough analysis. So if she's pulling in the Scalia card, I think it's good to note if she was clerking for him, she probably has already met half of the court, right? So she's probably already met Thomas, Chief Justice Roberts, and Alito, and Sotomayor, if she was clerking for Scalia. So they probably know who this woman is and has worked with her, just an FYI. So if SCOTUS ever gets involved in here, I think that's worth noting. All right, both right, instilled right, reason analysis. I've always considered it my obligation to pursue justice impartially, without favor to the wealthy or those who occupy important public office or harsher treatment for the less powerful. I therefore deem it necessary to the faithful discharge of my duties to raise the concerns expressed in this letter with you and to request an opportunity to meet to discuss them further. I cannot fulfill my obligations, effectively lead my office in carrying out the department's priorities. or credibly represent the government before the courts if I seek to dismiss the Adams case on this record. So sub A. Wow, we love this. We love that we are getting the full story here from her perspective. The government does not have a valid basis to seek dismissal, and that's one of the things that Mr. Bove may just be unfamiliar with. You actually have to have a valid reason, unlike, his actions in all of the Trump cases. Like, they could just ask for dismissal all the time. They didn't have to have any justification because it was just for funsies for them. But in reality, you actually have to have some good reason for it. Mr. Bove's memorandum identifies 2 grounds for the contemplated dismissal. I cannot advance either argument in good faith. As you know, the government, quote, may, with leave of court, dismiss an indictment, end quote, under Federal Rule of Criminal Procedure 48A, quote, the principal object of the leave of court requirement is apparently to protect a defendant against prosecutorial harassment, e.g. charging, dismissing, and recharging when the government moves to dismiss an indictment over the defendant's objection, end quote, and then citing case law. Quote, but the rule has also been held to permit the court to deny a government dismissal motion to which the defendant has consented if the motion is prompted by considerations clearly contrary to the public interest. This is the burden of, this is what the judge who's received that motion to dismiss will be assessing. The judge cannot dismiss this case if it's contrary to the public interest. That's the law. All right. So if we don't have that here, then we're in trouble. Ooh, someone's dad's here. Hi. Did she send the letter to the media? No, Victoria. This was sent directly to her supervisor. So next up, we have reflecting department's position that a court may decline leave to dismiss if the manifest public interest requires it. So perhaps the court would think maybe there is, but they will need to make that determination. We're going through Texas on 504 at any point. Maybe at some point. Hi, someone's dad. Right. So again, everyone, in the legal system, you have to have an actual reason to do stuff. You can't just do it for funsies. They released it. I mean, it's public record, right? Right. The reasons advanced by Mr. Bove for dismissing the indictment are not ones I can in good faith defend as in public interest and as consistent with the principles of impartiality and fairness that guide my decision making. Thank you so much. First, now again, remember those 2 conditions that they put in there. Not just for funsies. Well, exactly. I know, right? First, Mr. Bove proposes dismissing the charges against Adams in return. This is important for the quid pro quo for his assistance in enforcing federal immigration laws and analogizing to the prisoner exchange in which the United States freed notorious Russian arms dealer Victor Bout in return for an American prisoner in Russia. So again, that suggestion is supporting what she's saying here. Such an exchange with Adams violates common sense beliefs in the equal administration of justice, the Justice Manual, and the Rules of Professional Conduct, which is our ethics rules here. The commitment to the rule of law is nowhere more profoundly manifest than in criminal justice. And then we're citing the Cheney case, which is a landmark U.S. Supreme Court case. Alterations and citations are omitted here. Impartial enforcement of the law is the bedrock of federal prosecutions. And she's citing the federal prosecutor, which was written in 1940. As the Justice Manual has long recognized, the rule of law depends upon the even-handed administration of justice. The legal judgments of the Department of Justice must be impartial and insulated from political influence. But Adams has argued in substance, and Mr. Bove appears prepared to concede, that Adams should receive leniency for federal crimes solely because he occupies an important public position and can use that position to assist the administration's policy priorities. So, I mean, again, she's just calling him out on it. And one of the sad things is that Bove and these people think we're just going to be able to get our way. We're just going to bulldoze through everything because we're just that special. And people are coming out and saying, you're not. You're not more important than the Constitution. Federal prosecutors, he certainly does not have immunity. You're correct. Federal prosecutors may not consider a potential defendant's political association activities or beliefs. And she's citing another landmark Supreme Court case here, the Waite v. U.S. case. Politically motivated prosecutions violate the Constitution. If a criminal prosecution cannot be used to punish political activity, it likewise cannot be used to induce or coerce such activity. Threatening criminal prosecution, even to gain an advantage in civil litigation, is considered misconduct for an attorney. And she's citing a bar ethics opinion here. Quote, a prosecutor should not use other improper considerations, such as a partisan or political or personal consideration, in exercising prosecutorial discretion. Now, this dismissal would be prosecutorial discretion. That's why she's citing this. She's saying Bove is using his prosecutorial discretion to tell me to dismiss it. And his prosecutorial discretion is based off of political considerations, and that is unethical. In your words, the Department of Justice will not tolerate abuses of the criminal justice process, coercive behavior, or other forms of misconduct. Dismissal of the indictment for no other reason than to influence Adams's mayoral decision-making would be all three. Right. The memo suggests that the issue is merely removing an obstacle to Adams's ability to assist with federal investigation enforcement, immigration enforcement, but that does not bear scrutiny. It does not grapple with the differential treatment Adams would receive compared to other elected officials, much less other criminal defendants. And it's unclear why Adams would be better able to aid in immigration enforcement when the threat of future conviction is due to the possibility of reinstatement of the indictment, followed by conviction at trial, rather than merely the possibility of conviction at trial. So she's pointing out here that by dismissing this, they're going to be able to hold it over his head, right? Did everyone follow that? So you dismiss this case, then all they have to do is say, do you want us to file this case again? Did you do what we told you to do? Or we're going to file the case again because it was dismissed without prejudice, right? So anything Adams is like, oh, I don't know if I want to do that. It's unconstitutional or unethical, which I doubt he would ever say. But then all they have to do is say, well, fine, we'll just file your case again. So they're jerking him around here by holding this case over his head. And she's saying the only thing over his head right now is conviction at a trial, which, of course, as we all know, is 50-50. It's a 50-50 shot. So this is huge. This is huge. This amount of power, and for the AG to come in and say, well, we're going to charge, we're going to dismiss, we're going to charge, we're going to dismiss, is classic textbook situation where it's an abuse of prosecutorial discretion. All right, that's huge. On this point, the possibility of trial before or after the election cannot be relevant because Adams has selected the timing of his trial. So he's the one that actually put in that we're going to go to trial in April, and the judge was like, all right, that's fine. Rather than be rewarded, Adams's advocacy should be called out for what it is, an improper offer of immigration enforcement assistance in exchange for dismissal of his case. Although Mr. Bove disclaimed any intention to exchange leniency in this case for Adams's assistance in enforcing federal law, that is the nature of the bargain laid bare in Mr. Bove's memo. That is especially so given Mr. Bove's comparison to the Bout prisoner exchange. So again, it's his own words that incriminated him in this situation, which was quite expressly a quid pro quo, but one carried out by the White House and not the prosecutors in charge of Bout's case. So she's saying, hey, if it was done wrong, it was done by the administration, it wasn't done by our office. The comparison to the Bout exchange is particularly alarming. That prisoner swap was an exchange of official acts between separate sovereigns, the United States and Russia, neither of which had any claim that the other should obey its laws. By contrast, Adams is an American citizen and a local elected official who is seeking a personal benefit immunity from federal laws to which he's undoubtedly subject in exchange for an act. Enforcement of federal law he has no right to refuse. Moreover, the bout exchange was a widely criticized sacrifice of a valid American interest, the punishment of an infamous arms dealer, while Russia was able to extract only through a patently selective prosecution of a famous American athlete. It's difficult to imagine that the department wishes to emulate that episode by granting Adams's leverage over it, akin to Russians' influence in international affairs. It is a breathtaking and dangerous precedent to reward Adams's opportunistic and shifting commitments on immigration and other policy matters with dismissal of a criminal indictment. Nor will a court likely find that such an improper exchange is consistent with the public interest. So she's bringing this up again. She's saying, if you file your motion to dismiss, it's unlikely that the judge will actually dismiss it because it does not meet the level required for a dismissal of a case. And she's citing just one case here that says denying government's motion to dismiss where government has agreed to dismiss charges against certain defendants in exchange for guilty pleas by others. And then, here we go. We have another case in re U.S. describing a prosecutor's acceptance of a bribe as a clear example of a dismissal that should not be granted as contrary to the public interest. Now, we do have a footnote down here that just that we can just pull here. It came out of, where was it? Here we go. There's a footnote number 1. I attended a meeting on January 31st of 2025 with Mr. Bove, Adams's counsel, and members of my office. Adams's attorneys repeatedly urged what amounted to a quid pro quo. So she was at the meeting. Whoa, that's really bad. I mean, that's going to be some significant evidence there, indicating that Adams would be in a position to assist with the department's enforcement priorities only if the indictment was dismissed. Oh my gosh, she was in the room where it happened, everybody. She was in the room. Oh my goodness. Mr. Bove admonished a member of my team who took notes during that meeting and directed the collection of those notes at the meeting's conclusion. Whoa, that's shady, everybody. Here we go. We got to get the red pen out here. It's red pen time. Oh my goodness. Oh my gosh. Man, this Bove guy. Ooh, that's red flags, everybody. Red flags. That's a really big deal. Yeah, that's a really super big deal. Super, super big deal. So he took the notes of the person. Now, if that person is anything like, any other attorney's assistants, they probably rewrote those notes when they got back to the office. You know what I'm saying? Oh my goodness. This is so bad. Anonymous, well, yeah, they hacked the system. So I always find that very interesting. I am against using illegal means, but I still watch. All right, moving to page 4, everybody. Yeah, this is like a lot. Footnotes should always be read. Absolutely. I mean, that's where some of the biggest stuff is. All right. So we had number 1, which is very powerful. And then the second one here. Mr. Bove states that dismissal is warranted because of the conduct of this office's former U.S. Attorney, Damian Williams, which, according to Mr. Bove's memo, constituted weaponization of the government, as defined by the relevant orders of the president and the department. The generalized concerns expressed by Mr. Bove are not a basis to dismiss an indictment returned by a duly constituted grand jury. At least whereas here, the government has no doubt in its evidence or the integrity of its investigation. Again, this is huge. We are in beyond a reasonable doubt level of evidence, not just probable cause. The pen clue. Yeah, exactly. Oh my goodness. It's a lot, everybody. This is huge. This is the moment where we are where it's coming to this. This will be the situation. If this Bovey guy and this Bondi person retain their positions after this, we're in some really big trouble. As Mr. Bove's memo acknowledges, and as he stated in our meeting of January 31st of 2025, the department has no concerns about the conduct or integrity of the line prosecutors who investigated and charged this case, and it does not question the merits of the case itself. Still, it bears emphasis that I have only known the line prosecutors on this case to act with integrity and in the pursuit of justice, and nothing I've learned since becoming U.S. Attorney has demonstrated otherwise. If anything, I've learned that Mr. Williams's role in the investigation and oversight of this case was even more minimal than I had assumed. That's huge. That's going to be incredible testimony. The investigation began before Mr. Williams took office. Now, this is important because Mr. Bove, the whole reason why he's coming in is he's saying there was something hinky going on with the grand jury and with the prosecutor. And she's saying, I've seen it. I've seen it. No, there was nothing hinky going on. So there's not even a hint of abuse of prosecutorial authority. He did not manage the day-to-day investigation, and the charges in this case were recommended or approved by 4 experienced career prosecutors, the chiefs of the Southern District of New York Public Corruption Unit and career prosecutors at the Public Integrity Section of the Justice Department. That's a lot. Mr. Williams' decision to ratify the recommendations does not taint the charging decision. And notably, Adams has not brought a vindictive or selective prosecution motion. That's what I'm saying. This is what I'm saying right here, everybody. This is the proper mode of transportation for this kind of stuff. And he's not brought it. Nor would one be successful. And she's citing the Stewart case and U.S. v. Biden, rejecting arguments that the political public statements disturb the presumption of regularity that attaches to prosecutorial decisions. Again, this was a huge moment here. Regarding the timing of the indictment, the decision to charge on September of 2024, 9 months before the June 2025 Democratic mayoral primary and more than a year before the November 2025 mayoral election, complied in every respect with long-standing department policy regarding election year sensitivities and the applicable Justice Manual provisions. The Justice Manual requires that when investigative steps and charges involving a public official could be seen as affecting an election, the prosecuting office must consult with the Public Integrity Section, and if directed to do so, the Office of the Deputy Attorney General or Attorney General. As you are aware, this office followed this requirement. Further, the Justice Department's concurrence was unquestionably consistent with the established policies of the Public Integrity Section. Public Integrity Section here, Federal Prosecution of Election Offenses, 85 of 2017. Pre-election action may be appropriate where it's possible to both complete an investigation and file criminal charges against an offender prior to the period immediately before the election. So she's saying it's allowable by the law. The Department of Justice correctly concluded that bringing charges 9 months before a primary election was entirely appropriate. The timing of the charges in this case is also consistent with charging timelines of other cases involving elected officials, both in this district and elsewhere. U.S. v. Menendez, so that's the Gold Bars case, indictment of 2023, and U.S. v. Duncan Hunter in Southern California, indictment in August of 2018. I'm not aware of any instance in which the department has concluded that an indictment brought this far in advance of an election is improper because it may be pending during an electoral cycle, let alone that a validly returned and factually supported indictment should be dismissed on this basis. Again, the fact that a grand jury was pulled in, that's huge. That's huge. We can't discount our grand juries in this situation. Hope Williams is safe. I believe so. Again, this is an opinion piece that he wrote. If you want to do a little bit more looking into the situation, he wrote this on January 16th. So I thought it was pretty well written. Sorry, tea break, everybody. All right, let's, we're going to pick up speed here. We got to make up some time in the air, everybody. Here we go. When first setting the trial date, the district court and the parties agreed on the importance of completing the trial before the upcoming mayoral election, including before the Democratic primary in which Adams is a candidate, so that the voters would know how the case resolved before casting their votes. Adams has decided that he would prefer the trial to take place before rather than after the June 2025 primary, notwithstanding the burden trial preparation would place on his ability to govern the city or campaign for re-election. But that's his choice, and the district court has made clear that Adams is free to seek a continuance. The parties therefore cannot argue with the candor that dismissing serious charges before an election, but holding open the possibility that those charges could be reinstated if Adams were reelected would now be other than clearly contrary to the manifest public interest. So again, she's saying this can be held over his head while he is mayor here. Yeah, sorry, Sarah. There's something kind of weird going on with my camera where sometimes it fuzzes over. I've got the near-far situation, which I've not been able to figure out yet. Apologies. Mr. Bove's memo also refers to recent public actions by Mr. Williams. It's not my role to defend Mr. Williams's motives or conduct. Given the appropriate chronology of this investigation and the strength of the case, Mr. Williams's conduct since leaving government services cannot justify dismissal here. With respect to pretrial publicity, the district court has already determined Mr. Williams's statements have not prejudiced the jury pool. So that's already been decided. That's an important piece here. All right. We don't have an issue with the jury pool. That's big. The district court has also repeatedly explained that there is no evidence that any leaks to the media came from the prosecution team. Although there is evidence, media leaks came from the defense team and no basis for any relief. Wow. Mr. Williams's recent op-ed, the court concluded, generally talks about bribery in New York State. And so it's not a comment on the case. Again, that article I just showed you. Mr. Williams's website does not even reference Adams, except in the news articles linked there. And it is well settled that the U.S. attorneys in this and other districts regularly conduct post-arrest press conferences. Citing the Avenatti case, which we heard a lot about, New Jersey U.S. Attorney's Office press conference here and the YouTube site announcing criminal charges against 42 defendants. In short, because there is, in fact, nothing about this prosecution that meaningfully differs from other cases that generate substantial pretrial publicity, a court is likely to view the weaponization rationale as pretextual. This is, again, another key piece. So she's saying here that there is something behind going forward on this, and it's not something that is a legal argument. Moreover, dismissing the case will amplify rather than abate concerns about weaponization of the department, despite Mr. Bove's observation that the directive to dismiss the case has been reached without assessing the strength of the evidence against Adams. Adams has already seized on the memo and publicly assert that he's innocent and that the accusations against him were unsupported by the evidence and based only on fanfare and sensational claims. Confidence in the department would best be restored by means well short of a dismissal. As you know, our office is prepared to seek a superseding indictment from a new grand jury under my leadership, which is what Jack Smith did in the DC case. We have proposed a superseding indictment that would add an obstruction conspiracy count based on evidence that Adams destroyed and instructed others to destroy evidence and provide false information to the FBI. And that would add further factual allegations regarding his participation in a fraudulent straw donor scheme. Oh my gosh. So there's just so many more charges that could be. Oh, sorry. I forgot my sticky note. There we go. This is more than enough to address any perception of impropriety created by Mr. Williams's personal conduct. The Bove memo acknowledges as much, leaving open the possibility. I'm bringing my sticky note back, everybody. Here we go. Of refiling the charges after November of 2025, New York City mayoral election. Nor is conditioning the dismissal on the incoming U.S. Attorney's ability to reassess the charges consistent with either the weaponization rationale or the law concerning motions under Rule 48A. To the contrary, keeping Adams under the threat of prosecution while the government determines its next steps is recognized reason for the denial of a Rule 48A motion. And then she's citing the Poindexter case, allowing government to keep open the option of trying certain counts would effectively keep the defendant under public obloquy for an indefinite period of time until the government decided that somehow, for some reason, the time had become more propitious for proceeding with trial. Come on, people. Oh my goodness. All right, here's B. Adams's consent will not aid the department's arguments. So remember, that was part of the conditions here. Mr. Bove specifies that Adams must consent in writing to dismissal without prejudice. To be sure, in the typical case, the defendant's consent makes it significantly more likely for courts to grant motions to dismiss under Rule 48A. Citing case law, if the motion is uncontested, the court should ordinarily presume that the prosecutor is acting in good faith and dismiss the indictment without prejudice. But Adams's consent, which was negotiated without my office's awareness or participation, would not guarantee a successful motion, given the basic flaws in the stated rationales for dismissal. Here, and she's citing another case declining to rubber stamp dismissal because although defendant did not appear to object, the court's vested with the responsibility of protecting the interests of the public on whose behalf the criminal action is brought. So again, we've got this public interest element. Seeking leave of court to dismiss a properly returned indictment based on Mr. Bove's stated rationales is also likely to backfire by inviting skepticism and scrutiny from the courts that will ultimately hinder the Department of Justice's interests. In particular, the court is unlikely to acquiesce in using the criminal process to control the behavior of a political figure. So she's saying right here, she doesn't believe the judge will approve that motion to dismiss. And it's going to do some damage. Just by even going forward, some damage will be done for the Justice Department. Yeah, this is a problem. And I agree. I absolutely agree with her. A brief review of the relevant law demonstrates this point. Although the judiciary rarely will overrule the executive branch's exercise of these prosecutorial decisions, according to case law, courts, including the Second Circuit, will nonetheless inquire as to whether dismissal would be clearly contrary to the public interest. Further citation, extended discussion of contrary to the public interest standard in cases applying to it in her citations. Further citation requiring a written motion for leave to dismiss, explaining fully the reason for request to dismiss a case of public interest, well as for cases involving bribery. At least one court in our district has rejected a dismissal under Rule 48A as contrary to the public interest, regardless of the defendant's consent. Citing that case, it's saying, after reviewing the entire record, the court has determined that a dismissal of the indictment against Mr. Massat in that case is not in the public interest. Therefore, the government's motion to dismiss as to Mr. Massat must be and is denied. So she's setting out precedent where a judge has denied that dismissal on the same kinds of grounds. The assigned district judge, the Honorable Dale E. Ho, appears likely to conduct a searching inquiry in this case. Notably, Judge Ho stressed transparency during this case, specifically explaining his strict requirements for non-public filings at the initial conference. And she's citing where that happened. And a rigorous inquiry here would be consistent with precedent and practice in this and other districts. So again, she's just saying, fine, bring your motion, but the judge is not going to allow this to just be rubber stamped as agreeing to the dismissal. Nor is there any realistic possibility that Adams's consent will prevent a lengthy judicial inquiry that is detrimental to the department's reputation, regardless of the outcome. In that regard, although, let me make sure here. Yep, page 7. Here we go. And this is the last page, everyone. Although the Flynn case may have come to mind as a comparator, It is distinct in one important way. In that case, the government moved to dismiss an indictment with the defendant's consent and faced resistance from a skeptical district judge. But in Flynn, the government sought dismissal with prejudice because it had become convinced that there was insufficient evidence that General Flynn had committed any crime. That ultimately made the government's rationale defensible because, quote, insufficient evidence is a quintessential justification for dismissing charges. And then we've got another set of quotes ending that. As we know, this is I forgot his first name, but the Mr. Flynn that was given a pardon by the Mr. Trump in 2020. Here, no one in the department has expressed any doubts as to Adams's guilt. And even in Flynn, the president ultimately chose to cut off the extended and embarrassing litigation over dismissal by granting a pardon. Michael, thank you. Thank you very much. C, I cannot in good faith request the contemplated dismissal. So here's where she's going to draw her line, and she's going to say, look, I've got an oath. Because the law does not support a dismissal, and because I'm confident that Adams has committed the crimes with which he's charged, wow, that's huge as well. That's a huge piece. I cannot agree to seek a dismissal driven by improper considerations. As Justice Robert Jackson explained, quote, the prosecutor at his best is one of the most beneficent, sorry, I gotta look it up. There we go. Beneficent forces in our society. When he acts from malice or other base motives, he is one of the worst. And fully citing the federal prosecutor here, quote, this authority has been granted by people who really want the right thing done, wanted crime eliminated, but also wanted the best in our American traditions preserved. Well, that's a really great quote. I understand my duty as a prosecutor to mean enforcing the law impartially, and that includes prosecuting a validly returned indictment, regardless whether its dismissal would be politically advantageous to the defendant or to those who appointed me. A federal prosecutor is the representative, not of an ordinary party to controversy, but of a sovereignty whose obligation to govern impartially is as compelling as its obligation to govern at all. Whoa, that's another very, very powerful statement there. For the reasons explained above, I do not believe there is a reasonable argument in support of Rule 48A motion to dismiss a case, and that is well supported by the evidence and the law. I understand Mr. Bove disagrees, and I am mindful of your recent order reiterating prosecutors' duties to make good faith arguments in support of the executive branch's position. And she's citing that memo here. But because I do not see a good faith basis for the proposed position, I cannot make such arguments consistent with my duty of candor. Here, and she's quoting, a lawyer acting as an advocate in an adjudicative proceeding has an obligation to present the client's case with persuasive force. Performance of that duty while maintaining confidence of the client, however, is qualified by the advocate's duty of candor to the tribunal. She's quoting our ethics here. In particular, the rationale given by Mr. Bove, an exchange between a criminal defendant and Department of Justice akin to the bout exchange with Russia. Whoo, that's youch. Is, as explained above, a bargain that a prosecutor should not make. Moreover, dismissing without prejudice and with the express option of again indicting Adams in the future creates obvious ethical problems here by implicitly threatening future prosecution if Adams's cooperation with enforcing the immigration laws proves unsatisfactory to the department, citing the Christoph case, disciplining a prosecutor for threatening to renew a dormant criminal investigation against a potential candidate for public office in order to dissuade the candidate from running. So here we go. Here's the finale. Yowzers. So she's citing Notre Dame here, and here's our quote, noting that the Arizona Supreme Court disbarred the elective chief prosecutor in Maricopa County, Arizona, and his deputy, in part for misusing their power to advance the chief prosecutor's partisan political interests. Finally, given the highly generalized accusations of weaponization weighed against the strength of evidence against Adams, A court will likely question whether that basis is pretextual. Here, we're citing further pieces. Courts should be satisfied that the reasons advanced for the proposed dismissal are substantial and the real grounds upon which the application is based. I remain baffled by the rushed and superficial process by which this decision was reached, in seemingly collaboration with Adams's counsel and without my direct input on the ultimate stated rationales for dismissal, which is, again, huge. Mr. Bove admonished me to be mindful of my obligations to zealously defend the interests of the United States and to advance good faith arguments on behalf of the administration. I hope you share my view that soliciting and considering the concerns of the United States Attorney overseeing the case serves rather than hinders that goal. Wow. Yikes. And that we can find time to meet. In the event you are unwilling to meet or to reconsider the directive in light of the problems raised by Mr. Bove's memo, I'm prepared to offer my resignation. It has been and continues to be my honor to serve as a prosecutor in the Southern District of New York. Very truly yours, Danielle Sassoon. So, wow, everybody. This was amazing. This was an amazing letter here. This was so well written and backed up with precedent, case law, examples that she was giving, and justifications. Again, I would say one of the most powerful pieces in here is that she has said, I believe we've got enough evidence beyond a reasonable doubt. And that is huge. When a prosecutor says that, it means they're ready to take it to trial. So that's pretty significant. All right, everyone. We need, I really want to get, it's a long one tonight, everyone, but bear with me. This then is Mr. Bove's response. So let's take a look at this one. Let me put another sticky note in here. Yeah, we got to keep on keeping on. Why did she resign? Oh my gosh. All right. So Mr. Bove responds back. So DOJ Bove response to resignation here. All right, so here we go. That was scathing. Oh, absolutely. Translating. Oh, absolutely. I mean, this is quite the to-do, everybody. This is pretty major here. We're not just dealing with some, dumbass writing some language in an executive order here. This is some pretty major stuff. Oh, yes. All right, here we go. We have the response, and this was yesterday. So February 13th here. So Bove's response. Grabbing the popcorn. Get some popcorn, everybody. Miss Sassoon. Now, if I say her name incorrectly, I apologize. But Miss Sassoon, in response to your refusal to comply with my instruction to dismiss the prosecution of Mayor Eric Adams, I write to notify you the following. Whoa. That's rude. My gosh. We're going to put stars next to the aggression. I already feel gross. Oh my gosh. All right. First, your resignation is accepted. Oh my gosh. Because if you'll note, she says in here, please meet with me or I'm going to resign. And so he's just like, goodbye. This decision is based on your choice to continue pursuing a politically motivated prosecution despite an express instruction to dismiss the case. Wow, that's so nasty. You lost sight of the oath that you took when you started at the Department of Justice by suggesting that you retain discretion to interpret the Constitution in a manner inconsistent with the policies of a democratically elected president and Senate-confirmed Attorney General. Holy crap, everybody. Holy crap. Wow. All right. Oh my gosh. All right. This is a schmatzy. All right. This is one of the inner circle. Yeah, this is an inner circle person. Wow, with a law degree. Oh my gosh. Yeah. So we're in schmatzy land here. Second, you indicated that the prosecution team is aware of your communications with the Justice Department, is supportive of your approach, and is unwilling to comply with the order to dismiss the case. Accordingly, the AUSAs principally responsible for this case are being placed on off-duty administrative leave. Wow. So her whole team is getting put on administrative leave pending investigation by the Office of the Attorney General and the Office of Professional Responsibility, both of which will also evaluate your conduct. Oh my gosh. Wow. So, so he just, wow. Wow. Oh, all right. So her whole office now has been, oh my gosh. All right, number one, this leave status will remain in effect until further notice. This is not a disciplinary or adverse action. It's not. That's incorrect. And the AUSAs will continue to receive full salary and benefits during the administrative leave. And all of the cases that they're working on involving criminals are going to stall out. While the AUSAs are in an off-duty status, they are not to use their government-issued laptop, phone, and ID badge, PIV card, to access duty stations or any other federal facility unless explicitly directed to do so. Whoa. Whoa, 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 whoa. So first of all, we have a humiliation tactic. Yeah, I'm not taking any guests right now. Dude, seriously, stop asking me. You're screwing up my life here. All right, thanks. We've got a humiliation. Seriously, hold on, everybody. Sorry, had to get angry. Hi, how you doing? Coming to hang out on my live?
You are from?
Yeah, what's wrong? What you doing, man? Who are you? Are you here for
Okay.
fun?
My Pakistan.
What?